International Law and the Conflict in Gaza and Lebanon, hosted by the School of Law. I'd like to first start off with the acknowledgement of country. So Western Sydney University acknowledges the peoples of the lands upon which we are meeting today. We also acknowledge that the teaching and learning currently delivered across our campuses is a continuous of the teaching and learning that has occurred on these lands for tens and thousands of years. We pay our respects to the elders past and present of this nation and extend that respect to all other Aboriginal people. We acknowledge our gratitude that we share this land today, our sorrow for the costs of that sharing, and our hope and belief that we can move forward to a place of equity, justice, and partnership together. I am one of the law students and associates of the Palestine Project, and I will co-host today with the Dean of Law, Catherine. So today's webinar will feature Professor Tim McCormack. I believe he wants to be called Tassie. And he's a leading expert in international law. So with his extensive experience as a special advisor on war crimes to the prosecutor of the International Criminal Court, and his involvement in high-level multilateral treaty negotiations, Tassie will offer an in-depth analysis of how international humanitarian law applies in these conflicts. His distinguished career, which includes the Foundation Directorship of the Asia Pacific Center for Military Law, and multiple advisory roles to the Australian government, ensures a comprehensive exploration of the legal frameworks governing military conduct and accountability. This webinar is an essential opportunity for scholars, students, and professionals in international law to engage with pressing issues of war crimes, humanitarian protections, and the challenges of enforcing legal norms in ongoing conflicts. So before I give it over to Catherine to ask the questions, I just want to let everyone know that please feel free to put your questions in the chat and we will ask them as we go. Thanks, Catherine.
Thanks so much, Iram. And I add my thanks to Professor McCormack for joining us this morning. He really is one of the world's leading experts in this area. Iram mentioned the Palestine Project, and I'd just say a short word about that. In the immediate aftermath of the events of 7 October and the response from Israel, the law school established a project which has 3 main purposes. The first is to provide, as educators, support for our students who were experiencing severe emotional distress and trauma in our classrooms as a result of the way the conflict was playing out overseas. And we understand here in the School of Law that educating our students is not just about teaching them the content of the law, it's about recognizing and reflecting in our teaching the real anxieties that they're experiencing in their personal lives. And secondly, we thought it was important to preserve a place for academic debate and discussion and discourse about the most difficult issues that many of us will experience in our lifetime. And thirdly, the Palestine Project shows our ongoing commitment to the rule of law and to international law. So we have on our website this project that has the colours of the Palestinian flag alongside it. But we hope that that project is a signal to every oppressed minority group across the world that this is a law school that will stand for the rule of law in relation to whatever injustice they are experiencing, as well as the Palestinian people. So this is an important event for us, this discussion with Professor McCormack. We know all too well now what happened following the 7th of October and where we are now following a full-scale invasion of Gaza by Israel on the 27th of October. And that is the deaths of 43,000 Palestinians and the destruction of most of the buildings in Gaza. And we know that this conflict has now expanded to Lebanon and that Israel is now bombing Beirut. We have hundreds of deaths of civilians and thousands of people wounded. So I think we might begin, Tim, with first principles here. Are there legal frameworks that govern the sort of conflict that we're seeing now in Gaza and Lebanon? And how are they being challenged or applied in the current situation?
Yeah. Thanks, Catherine. Look, maybe just a couple of prefatory comments, if I can. I join you from Tassie. I don't call myself Tassie. I come from Tassie, and I'm on the country of the Muwinina people, and I also pay my respects to them. I wish actually that I was physically present at your law school today, because I'd much rather engage with you face to face, but I'm sorry that that can't happen. But thanks very much for having me. It's an absolute pleasure. The 3 objectives of the Palestine Project, I think, are fantastic, and I applaud you for the initiative, because I can understand that all 3 of those things are really important objectives to work towards. So just in terms of first principles, absolutely, the international legal framework applies, but unfortunately, the geopolitics around this conflict mean it's not being applied as it should be, and I think that's sort of a bottom line. For example, the prosecutor of the International Criminal Court, having announced his decision to request arrest warrants against Benjamin Netanyahu and Yoav Gallant for, amongst other things, the alleged war crime of starvation of the Palestinian population of Gaza, because of the deliberate obstruction of delivery of aid and humanitarian relief, food, water, you name it, medical supplies, etc. He announced publicly, within days of announcing that decision, that an unnamed senior official of an unnamed country, I suspect the US, but I don't know for sure, rang him to abuse him over the phone, to say the International Criminal Court exists for Africa and for thugs like Putin, not for Western liberal democracies like Israel. Come on, you can't do this. Well, really? I mean, is that really the truth? Of course, Karim Khan doesn't believe that, fortunately. Otherwise, I would have resigned on the spot if he'd decided to buckle to that sort of pressure. But for me, it's sort of indicative of what we're dealing with here. We have an international legal framework that we as international lawyers believe should be applied systematically and objectively on the basis of the factual situation. And right now, Israel's getting away with egregious violations of it, and it's being shielded from the consequences that ought to flow to it by particularly the US, but other Western nations.
So the International Criminal Court investigation of the actions of Israel's leader and of Hamas is not the only international legal proceeding on foot at the moment, is it? We've heard reporting about the Genocide Convention and whether and how that might apply. Can you explain those proceedings as well?
I certainly can. So you have the International Criminal Court headquartered in The Hague, with jurisdiction over the international crimes of genocide, crimes against humanity, and war crimes. And because Palestine is a state party to the Rome Statute, which establishes the International Criminal Court and governs the court's jurisdiction, then Karim Khan, as prosecutor, has the authority to investigate alleged Rome Statute offences occurring on the physical territory of Palestine, which includes Gaza, the West Bank, and East Jerusalem. He doesn't have jurisdiction over Israel's conduct in Lebanon, because Lebanon is not a state party to the Rome Statute. So already you start to see limitations to how the international legal framework can be applied. In the case of the International Criminal Court, it has jurisdiction in some situations and not in others, because of the way the statute's structured. But 6 kilometres away from the International Criminal Court in The Hague is the International Court of Justice in The Hague, a completely different legal institution. The ICJ, much older court, established as the major court of the United Nations system. And the ICJ has jurisdiction over cases between sovereign nation states. International Criminal Court tries individuals for alleged international crimes. The International Court of Justice tries cases between countries. And the major, there are two cases that have been happening at the ICJ related to the Palestine-Israel situation. One of them was bought by South Africa because South Africa and Israel are both states parties, as is Australia and many other countries, both states parties to the 1948 Genocide Convention. And under Article 9 of that convention, the International Court of Justice has jurisdiction to decide a case involving alleged violation of Genocide Convention obligations. And any state party to the Genocide Convention can launch proceedings in the International Court of Justice against another state party that it believes is perpetrating genocide. In my view, thank God for the South Africans, because they initiated legal proceedings against Israel, arguing that what the Israelis were doing and are doing in Gaza since October the 8th constitutes violations of genocide. And yeah, we can talk a little bit more about that case, but it's happening. It's an ongoing legal proceeding. The court's already made orders of Israel that Israel's completely ignoring. So that's frustrating for international lawyers. There's a second case that's been decided by the ICJ. It doesn't involve two countries in contentious proceedings in a case against each other, but the court also has what's called an advisory jurisdiction. That is where, in this case, the UN General Assembly asked the International Court of Justice to provide its international legal views on the implications of Israel's prolonged occupation of Palestine since 1967. Well, particularly since 1967. Those are the students who know the Israel-Palestine conflict well know that the takeover of Palestinian land predates 67, but West Bank and Gaza and East Jerusalem were all occupied by the Israelis and have been ever since 1967. The International Court of Justice in that decision has been castigating of Israel's violations of its obligations as an occupying power. And they're all happening at the same time. None of them at the moment are impacting upon any or having any effective constraining influence, I could say, on the way Israel's going about its military operation.
So let's stay with that effectiveness issue for a moment then. What are the remedies of states if a state like Israel doesn't comply with orders of the International Court of Justice?
So I think what member states of the UN, who are also states parties to the statute of the International Court of Justice, and that includes Australia, my view is that they should take seriously an advisory opinion like that. And on the basis of their bilateral diplomatic relations with Israel, not only protest what's happening, but think about imposing sanctions. I read last week on the BBC online news that the new British government of Keir Starmer is contemplating the imposition of sanctions against two extreme right-wing members of the Israeli cabinet, Itamar Ben-Gvir and Bezalel Smotrich, both of them shockers in my view. And if the British were to do that, I think that would be a really important move. I hope it happens. I think it might then put some pressure on Australia. We're so ready to sanction Iranians, we're so ready to sanction Russians, but they're baddies in our minds. We need to be sanctioning the Israelis to increase the pressure. Australia's done, we can talk a little bit about Australian government responses, of course, in due course. There have been a few things that Australia's done differently and copped some serious criticism and condemnation from News Corp and the Israeli lobby, if you could, Jewish lobby in Australia. But I think there's so much more that we could do, and countries like us could do to tell Israel, to send an unambiguous message that what's going on is completely beyond the pale, unacceptable, illegal, even criminal.
So the most powerfully effective, unambiguous message would probably come from the United States
It would.
in terms of Israel's conduct. But from the United States, we've seen the continual supply of weapons to Israel to carry out what may be, depending on the International Court of Justice, eventual decision, a genocide in Israel. So what are the implications for states that are parties to the Genocide Convention, like Australia, of a failure to respond to prevent a genocide?
Yeah, it's a really good question, Catherine, and there's no question that Israel experiences the level of impunity that it does and has done for decades because of US support. If the US support evaporated, then wouldn't matter if a few Western European countries persisted with, sort of blind support for Israel, uncritical, unquestioning support, because then they would have to change the way they operate. The fact is, the US provides veto in the UN Security Council. Security Council's is hamstrung in being able to take any substantive measures against Israel. That's the body that has the authority to do it, but it can't because the US is such a faithful ally of Israel. And it'd be interesting, perhaps we maybe in Q&A we can talk a little bit more about this. Why is that the case? It's not just the power of the Jewish lobby in the United States. Tragically, from my perspective, evangelical Christian America is blindly supporting everything Israel does, and they represent such a significant electoral bloc that none of the major parties are prepared to lose the support of them by taking a much tougher stance against Israel. So we can talk some more about that. But the question you're asking is, what are the implications? And of course, one possible allegation is that by refusing to condemn Israel's genocide in Gaza, we are complicit in it. And not just complicit in the sort of political sense of indifference to it, or failure to condemn it for what it really is, but potentially complicit in the legal sense. And genocide is accepted as a particularly serious international crime. The International Criminal Court has jurisdiction in relation to it in Gaza. And potentially, I think it's unlikely, but and we can talk some more about what I mean by that. Unlikely, but potentially, the ICC has jurisdiction over Western leaders for their complicity in Israel's genocidal conduct in Gaza.
Let's stay with that question of the United Nations and the various organisations under the mantle of the United Nations. So we've seen the legal avenues open to the International Court of Justice ignored by Israel. We've seen the political problems which constrain the effectiveness of an ICC investigation. Are there other United Nations bodies or the Office of the Secretary General or that could have the power to change what's happening on the ground in Gaza and in Lebanon?
Yeah, thanks, Catherine. Good question. Every single UN agency, whether it's with the Secretary General himself and his sort of good officers of his authority and his position, UNRWA, UN Office of the Coordination of Humanitarian Affairs, we call it OCHA, the UN Human Rights, the Commissioner for Human Rights and her office. Every single UN agency is saying that the situation on the ground is amongst the worst that they've ever witnessed. And, please, they're pleading with the international community and the members of the UN to accept that what's going on is it's an egregious violation of international legal rules. And I don't know what more the UN could do. The General Assembly You know, it could try to censure Israel. It's tried multiple times to admit Palestine as a full member state of the UN, and to condemn Israeli practices. But in the end, the Security Council is the executive body of the United Nations, and that's where the authority really lies to impose substantive measures. The UN Human Rights Council, is often taking its lead from the UN Human Rights Commissioner. There are things that it can do. It can pass resolutions. It can hold inquiries. It's certainly done that already in relation to the situation in Gaza. It can condemn Israeli policies, but it doesn't have the teeth to be able to really impose sanctions or to undertake criminal proceedings itself against Israeli leaders.
Tim, you mentioned just then the question of statehood and Palestinian statehood. So can you tell us something of the background to that and what difference you think that might make to the ability of Palestine to protect the people within defined state borders? Or
so international lawyers, we have this tendency to revert to a document to help us out when we want to sort of define things. And my youngest, about 3 adult children, is a philosopher, and he says to me, the problem with you lawyers, Dad, is you just place way too much emphasis on what the document says, and you don't sort of address the systemic and structural weaknesses and problems. I get that. I understand. Thanks for helping me out. But we go back to 1933 on the criteria for statehood to a particular Latin American treaty called the Montevideo Convention. You know it well, Catherine, I know, but maybe the students don't. There are 4 criteria articulated in the Montevideo Convention for statehood, and they are a permanent population, a defined territory, a government with the ability to exercise authority, and the capacity to enter into international relations with other sovereign nation states. Now, those 4 criteria are satisfied by Taiwan, for example. There's no ambiguity about that, but Taiwan stops short of declaring independent sovereign nation status because of the politics of its relationship with Beijing. And so it says we don't need to declare ourselves a state because we already satisfy the criteria of statehood. They know that the moment they declare the independent statehood, it's all over for Taiwan because that's intolerable for People's Republic of China. For me, that's a great case study in what does statehood really mean. The issue with Palestine has always been, well, at least the Israelis, I would say, have exploited the 4 criteria to say, well, Palestine doesn't have a defined territory because the borders haven't yet been finalized by negotiation. This, for me, is like just a cloak to try and hide the fact that it's extremely politically convenient for Israel to make an argument like that. The reality is, in 1948, when Israel was declared itself a sovereign nation state and was subsequently admitted to full membership of the United Nations, its borders were also not defined. So, how these 4 criteria are interpreted and applied is always subject to sort of political sensitivities. And if the right number of states and the right states, in terms of big players, all recognize the newly independent state or the newly declared independent state, then it's all smooth sailing for that particular entity. If they don't, then all sorts of trouble, all sorts of obstacles are put in the way of the entity enjoying full statehood. And for Palestine, it's never been admitted as a member of the UN, not for UN General Assembly lack of support. The last time round, there was a vote for Palestinian statehood. 155 of 194 members voted in favour. You only need 2/3 majority. It's about 129, I think, is the magic number. So, this is overwhelming political support. But that decision is also subject to the UN Security Council veto, and the US vetoes it. Has done every single time it's been put to the Security Council. So you've got this sort of artificial situation where Palestine isn't able to confirm its sovereign nation status through UN membership, UN state membership. But that doesn't mean, it's all over. What the Palestinian Authority has been able to do is have Palestine admitted as a state party to UNESCO, the UN Economic, Social, Cultural Organization, and various other UN agencies. And most importantly, from my perspective, in terms of the ICC, the International Criminal Court's jurisdiction, Palestine lodged an instrument of accession, a document to apply to become a state party to the Rome Statute. Only one state party, there are 125 of them now, only one of them objected to that application. That was Canada, on the basis that we don't recognise Palestine's independent state, so Palestine can't become a state party to the Rome Statute. No other state objected, including Australia, the UK, Germany, France. The list goes on and on and on. No objections. So Palestine was admitted as a state party. And in 2019, the then prosecutor of the International Criminal Court tested with the judges their view about this. We know, her position was, we know that there's some contestation around Palestine's status in international law. Please tell us whether, from your perspective, the court has jurisdiction over conduct on the physical territory of Palestine or not, because we only want to invest the resources to investigate alleged crimes there if we know that you're not going to turn around and tell us years down the track, sorry, Palestine not a state party. And she has the authority to do that under the statute. It's a particular provision of the Rome Statute that allows her to seek clarification on the court's jurisdiction. The pretrial chamber met and decided that, yes, without prejudice to the broader question of Palestine's international legal status, which I think they're correct, the judges of the ICC is not competent to decide, not a question for the International Criminal Court, is Palestine a state in international law? That's a question the International Court of Justice can decide, but not the ICC. So without prejudice to that resolution of that issue, for the purposes of the Rome Statute, Palestine is a state party, and this court has jurisdiction over conduct occurring on the physical territory of Palestine. That's a massive breakthrough. And for the Palestinians, I think they thought, the Palestinian Authority, I should say, not, average person on the street, probably wouldn't give a stuff, and rightly so, because it's resulted in no benefit to them. But the Palestinian Authority, I think, thought that was a big breakthrough, because now we are in a forum that may be able to hold leaders of, the Israeli government to account.
And do you think Australia's recognition of Palestine would make a difference?
Yes, I do. I think the more Western countries that recognise Palestine, especially allies in the United States, that recognise Palestine as a state, the better. And I think that because the Israeli government, successive Israeli governments, have been able to use the lack of statehood as a sort of way of saying, we've got to, you can't, if you recognise Palestine prematurely, as in before there's a negotiated peaceful settlement to this conflict, then you undermine the efforts to peacefully resolve the situation. But that's a convenient argument, isn't it? Because then they have done nothing substantive to facilitate a negotiated settlement. There isn't a peace process going on. It's the exact opposite of that. It's exploitation, confiscation of yet more land for settlements in the West Bank, some illegal outposts, and expansion of existing settlements. It just goes on relentlessly, and there is nothing the Israeli government is doing to try to change that. So I just think to myself, what peace process are you blokes talking about? This is just a convenient argument to prevent substantive progress towards a two-state solution. And I happen to believe much more firmly now, probably than I've ever done before, that the more states that recognise Palestinian statehood, the better.
Tim, do you see changes in Australian policy or voting patterns in the UN that would indicate that we are coming to that position?
I do. And, I think from the Labor government perspective, they probably, I suspect Penny Wong, as foreign minister, wishes that she's given more credit for some of the changes. The changes are, but in fairness to the protest movement, the changes are so they seem minor and insubstantial. From an Australian government perspective, when you're being sort of wedged between News Corp and the coalition, I mean, Peter, some of the things Peter Dutton's saying are absolutely outrageous. So, but the government has to be, well, I don't know, it has to be, are hypersensitive to the relentless criticism that they're too pro-Palestinian, too anti-Israel. But yeah, there have been some shifts. So, for example, very early on in after October the 7th, and then the Israeli response, which commenced the next day, Penny Wong unambiguously called for a ceasefire and has consistently done that. In the UN, we've moved from voting against a resolution in the General Assembly condemning Israel to abstaining. From this government's perspective, that's a big shift, and wish we'd get some credit for that. I think with what they would probably say, but it's still a few steps short of recognising Palestinian state. Penny Wong has said we're open to considering that, and I'm sure the Labor government's more likely to at least consider it than Liberal National Coalition government would.
Thanks, Tim. I'm going to hand over to Irem now, who has been looking at questions that have come through from the audience.
I've seen a few myself, but it's a little bit hard to speak and also follow them. So I'd like to say that people have asked them, thanks heaps, and hopefully we can work our way through some of them. I really hope my answers to your questions haven't been too long and convoluted, Catherine.
No, it's been fantastic so far. We'll see what comes through from the audience.
Sure.
Thanks, Catherine and Tim. Okay, so we've got quite a couple of questions. So the first question we've got from one of our law professors, and he's asked, hasn't Israel, armed by the US and backed by other Western powers, blatantly disregarded international law, confident of immunity?
Yeah, absolutely. And they will never say that, of course. They will, the rhetoric is always, we have a right to defend ourselves. We only attack military targets. It's all Hamas's fault because they built this tunnel network under all of Gaza. So, everywhere in Gaza then is a legitimate military objective because we're trying to get the tunnels underneath or to the command and control centers that they've set up in schools and hospitals and universities and libraries and mosques and everything of cultural and historic and religious and educational significance. But the reality is that in this vengeful response to October the 7th, the Israelis have dispensed with all the constraints that they might have applied in previous military operations in Gaza, and they're, I think, hell-bent on smashing the place up so badly that it's totally uninhabitable. And then if it gets rebuilt, it'll get rebuilt in the way that Israel decides it wants it to be rebuilt and wants it to be resettled. The calls of the more extreme far right elements of this Israeli government coalition about, we've got beachside opportunities to create new settlements, I find that absolutely horrifying. So yes, I mean the short answer is yes, and there are lots of ways in which that's happened, and it's really sad that it has.
Yeah, definitely. And I think going on to the next question, geopolitical realities, that is a polite term for US and global imperialism. Doesn't this make a mockery of international law?
Well, yeah, I mean, it's hard to argue that international law, you can't argue international law is making a difference. If you sort of canvassed opinion on the streets of Ukraine or on the streets of Gaza or the West Bank or in southern Lebanon, I mean, people would rightly, and I'm sure almost unanimously say, well, that's got to be bullshit, however you express that in Arabic or in Ukrainian. I mean, come on, who are you kidding? You're trying to kid. So I understand that that skepticism here. We're facing as an international community some of the greatest challenges to the rules-based, international order. And I'm actually quite relieved and glad, in one sense, that the major international courts are standing tall and applying principle and calling out violations. But I also have to accept that that's not enough. And in the end, if all we have is the ICJ and the ICC demanding that Israel changes its operation, demands that Israel opens up access to humanitarian relief at scale, and what we mean by that is back to 500 trucks a day into Gaza, um, or in the case of the International Criminal Court, that the judges actually finally have the courage and the nerve to act on the evidence they've been presented with and to issue the arrest warrants against Netanyahu and Gallant. Unless that happens, I mean, that's not enough, actually, and that has to all happen. But I think unless the international community of states, including the West, that in the past has tended to support Israel, unless they're prepared to say international law has to apply to everyone, and until it does, we make a mockery of the pretense that it does. Yeah, I think that position that's articulated in the question is one that's very difficult to argue with, and it's an entirely defensible position.
Thanks for that, Tim. We've got another one of our lovely law professors asking about whether you have any reflections about the hesitancy with some people using the term genocide to describe this genocide, and the hesitation seems to imply waiting for the ICJ ruling. But is there any merit in this waiting for the determination of the obvious?
I've been very circumspect in the use of the term myself, because I felt constrained while I was in the role of special advisor to the prosecutor of the International Criminal Court. So in fact, I wouldn't even be participating today if I was still in that role, because I'd say, no, I can't really do that. If Catherine had approached me about that, I would have said, no, I can't do it, not yet. When it's over, yeah, sure. My role finished in the last week of September, so I've been free now to say what I really think. Up until the end of September, I would not have said publicly that I thought what was happening in Gaza was genocide. And I wouldn't have also said publicly that I thought war crimes and crimes against humanity were being committed, even though that's obvious. And that's because I have to, in the public domain, while I'm involved in giving legal advice about the investigation in The Hague, I have to be really careful about declaring something to constitute a crime, which is yet to be proven by the court. So they were professional constraints on me. Now that I don't have them anymore, and I mean I do, that's not an absolute statement. I am still constrained by the confidentialities of the information to which I've been exposed and involved in advising about. So I won't be talking about any of that. But I can say what I think now, which is great. I mean, that's a liberation in one way. I would still say, better be careful not to rave on too much, but I would still say it was a wonderful privilege to be involved on the inside, and I had to accept that comes with certain consequences about academic freedom, something that we would always take very seriously and hold precious and dear. When you're engaged in a criminal investigation, you don't have academic freedom anymore, and you got to weigh up, what's more important. So now I'm liberated. I wouldn't hesitate to use the term, and I know that me saying that shock a lot of people from the Jewish community in Australia, who I know and have worked with over the years. They'd be horrified, but the fact is, I don't know how you can argue that's not the case. I mean, of course, if you look at the statements of the Israeli government, they're very careful about, what to say, what they're trying to achieve. But we don't in a criminal investigation, we don't just look at what people say, obviously. I mean, sometimes there are explicit statements that are not only genocidal, but also inciting others to commit genocide. And there have actually been plenty of them coming out of Israeli leaders' mouths, not Netanyahu, not Yoav Gallant, but some of the more right-wing members of the coalition. More right-wing than them, I should say. A lot of them are right-wing, but yeah, some of them are more extreme. But the reality for me is that look at the actions, at the conduct, everything of significance to the Palestinian people in Gaza has been smashed up. And I just don't accept that every single one of those targets hides a Hamas command and control cell. So apart from the destruction to the residential buildings, everything of cultural, like I said before, I gave you a list: cultural, historic, religious, educational significance has been destroyed. And we've got, with so many YouTube videos of glee and rejoicing on the part of Israeli soldiers as they watch this stuff being blown up. So what is it if it's not genocide? I mean, give me another label that describes what the hell is going on in Gaza, that this destruction needs to be so absolute and so widespread.
Thanks for that. So we've got another question. So can Australia join the case against Israel at the ICJ?
Like, you mean the South African case? Yeah,
Yes.
they can, and a number of other states, countries have in international law, you use the term states. I'm not talking about state of origin. Like, I lapse into that terminology because I'm so used to it. I mean independent sovereign nation states. A number of other countries have applied to the ICJ to join the proceedings. So South Africa, did a great job, I think, in leading the initiation of the proceedings. We're probably, I suspect, still 8 to 12 months away from the stage at which the ICJ will hear the merits of the case, the substantive argument about what Israel's doing constitutes genocide. So what's happened so far are provisional measures, orders that the court has made. I guess like those law students amongst you, it's the equivalent of an injunction or injunctive relief, where a court says, we're going to decide the case, but in the meantime, you've got to stop this practice so you don't prejudice our ability to undertake the consideration of the substantive merits of the case and then decide, what behaviour is illegal and what isn't. So we're still some time away, just because of the amount of time it takes for an ICJ case to come to that stage, and there's time for other states to apply to join the proceedings between now and when the court hears the oral pleadings in the merits stage of the case. And if Australia wanted to, that's absolutely one thing that we could do. I'm not suggesting that we will, but I certainly would applaud it if this government decided to do that.
Yeah, I mean, it would be a massive breakthrough, I think, if that was to happen. But moving along with another question from one of our lovely professors, noting the external threats against ICC staff, can you shed any further light on the cause or potential causes of the delay in the ICC pre-trial chambers resolution of the prosecutor's request for arrest warrants against Israeli leader, and what can be done to compel the PTC to act or to reconstitute the chamber?
Yeah, great. Thanks for the question. So let me perhaps explain a little bit of the background to that question for the benefit of those who don't know the International Criminal Court well, or at all. And I suspect there are a few out there in the audience. The process at the ICC is that the prosecutor requests of the pre-trial chamber. So there are 18 judges in the International Criminal Court, and they're assigned to different chambers. We call the pre-trial chamber, the trial chamber, and the appeals chamber. Pre-trial chamber decides, as you'd expect by that title, the pre-trial matters, which include the decision to approve the issuance of arrest warrants. A pre-trial stage of proceedings we call the confirmation of the charges, where the prosecutor has to establish substantial grounds for believing that these individual accused are responsible for these specific Rome Statute crimes, and a whole lot of other administrative pre-trial matters. The prosecutor has no authority to issue arrest warrants himself. So he has to go to the pre-trial chamber, as he did in June, and request the pre-trial chamber to issue the arrest warrants. And the test that the pre-trial chamber is supposed to apply, when I talk about pre-trial chamber, I'm talking about a panel of 3 judges. Those 3 judges assigned to this particular case or this situation, the test for them is a very low threshold test, reasonable grounds for believing that these individual accused are responsible for these specific Rome Statute crimes. Now, the prosecutor, before he made that request, some of you will have read about this, went to assembled a fairly high level panel of supposed subject matter experts. I think they were actually predominantly from the United Kingdom. Amal Clooney, who's a special advisor to the prosecutor, and several other high profile lawyers in the UK to check with them whether they agreed that he had a prima facie basis to make that arrest warrant request. Now, I suspect the prosecutor, I haven't talked to him about this, and I'm not breaching confidentialities because I'm not privy to any confidential material on this, but I suspect the prosecutor is just trying to cover himself to say, this isn't just me acting on some whim in the middle of the night that comes to me, I need to apply for arrest warrants. I've checked this out with some others whose opinion I trust, and I'm going to, on that basis, apply. Now, unfortunately, from my perspective, the judges who have a pretty straightforward request to respond to, and in the history of arrest warrants at the ICC, have never done what these 3 judges have done. Sometimes they've taken weeks, sometimes they've taken a couple of months, but not 6 months. They have not, these judges have gone out to the world and invited written submissions on whether or not they should issue the arrest warrant. What? Are you kidding me? Now, you can say, of course, that in this highly politically sensitive, this highly politically charged situation, judges are just trying to cover themselves, like Karim Khan did something else to cover himself. They're trying to cover themselves. They've received 70 amici curiae briefs. In response to that call, they're going to have to consider all of them. And on balance, they might decide we'll issue the arrest warrants because that's where the weight of numbers. I mean, I don't know what basis they're going to decide it. Why can't you just decide on the basis of the evidence that's been put before you? I'm really upset about it actually, because I think that this delay doesn't increase any pressure at all on the Israelis in their operation in Gaza. And I would have much preferred the judges to have come back in 2 weeks or in 4 weeks and said, well, we can only act on the evidence before us. Prosecution still carries the onus of proof. If it comes to trial, they've got to prove the elements of each of the offences beyond reasonable doubt. Here's the arrest warrants. And off they go. But yeah, that hasn't happened, and it's deeply frustrating. I think it's ironic, actually, that the 3 Hamas leaders that were all named in the same request for the issue, or not the same request, but at the time that the requests were made in respect of Netanyahu and Gallant, they were also made in respect of Sinwar and Dief and Haniya, and Israel's killed all 3 of them. If Hezbollah had the capacity to kill Netanyahu and to kill Gallant, both of whom, by the way, are legitimate military targets in terms of international humanitarian law and their role in the armed conflict with Hamas and with Hezbollah. If they were able to kill them, then I guess that'd take a bit of pressure off the judges of the pre-trial chamber, wouldn't it? They wouldn't have to make a decision anymore, because all 5 people, the subject of the arrest warrants, would be dead, and you don't issue arrest warrants at the ICC posthumously. But really, is that what they're waiting for? I'm very frustrated by it. I feel like their job is to respond to the evidence that's been put before them. I also believe very strongly that Karim Khan's job is to act on the evidence before him, and he did that to his credit. And now the judges, they've introduced this step that's not required, and that has caused a massive delay. Now, question: can the panel be reconstituted? That's a decision for the president of the court, and it's never happened before that a panel's been reconstituted because it hasn't made a decision in a sufficient time frame. There've been panels reconstituted where one judge has died or become very sick and had to be replaced, but not for these sorts of reasons. So, I mean, I think it probably could happen, but it'd be a unusual step and probably internally within the institution of the court, quite a controversial one.
Thanks, Tim. So the next question that we have is, do you have any thoughts on what sort of pressure can be placed on the Australian government to sanction Israel and impose an embargo on arms-related exports?
Yeah. Well, we know that all Australian governments are susceptible to electoral pressure. So I think, I had the interesting experience of going to listen to Penny Wong at the University of Tasmania just last week. I was telling Catherine before we started, I took my son, my 22-year-old, the same one is, the philosopher keeps challenging me. He's in the protest movement down here. I've never joined him while I was special advisor on war crimes. Now I probably can, and I suspect I will. But on this particular occasion, I did not. I was invited to, be part of the audience. So I dropped him off out the front to participate in the protest, and I went inside and tried to listen to Penny Wong, but she was interrupted every 2 or 3 minutes by people that got themselves into the lecture theatre. It was 500 people there. It's a big event. They were very strategic in standing up and interrupting her to yell out, or to ask questions, or to voice their frustration and despair about the lack of Australian government substantive pressure on Israel. I think she's getting that message wherever she goes, and I think not just her, but other members of the cabinet, as they try to speak at public events around the country, especially at universities. They understand that there's a great deal of anger and frustration and skepticism about international law not being applied consistently. I think she understands that. How do we increase the pressure on her and the rest of the government to take more substantive measures? They're copying a lot of pressure from the other side. That's part of the problem. So, News Corp, if anybody had any influence over local News Corp paper that could get a pro-Palestinian perspective into it, you'd probably be stymied by editorial policy in relation to all the media outlets. But I feel like that's, as well as the sort of numbers of people participating physically in protests and letting the government know they're not happy, and letter writing and lobbying of local members, there has to be some sort of counterweight to the incredibly partisan position that News Corp is taking in, a sort of rabid pro-Israeli position, to, I suspect, to see any really substantive shift in Australian government policy. I might be naive about that, but yeah, I'd really like to see that if I could. If I live long enough, I mean.
Thanks, Tim, for that. Catherine, did you just want to jump in, as I know Tim has to leave at 12 o'clock for his son's birthday?
Is this the same son, Tim, who's the philosopher? And
He'd be embarrassed to know that I refer to him so often, but I can remember the day he was born 23 years ago, sorry. And I was so proud. Like, my wife was in intense labor, at 11 p.m. on the 23rd. And I just thought, I didn't say it because I got smacked in the mouth, and deservedly so, but I just wanted her to hang on till after midnight, because then he'd share a birthday with the UN. Because the 24th of October is the anniversary of the opening for signature of the UN Charter. And I thought, as an international lawyer, like, I wish I could say I planned that, but this was bloody awesome timing, coincidence of timing. And so, yeah, so it is. It's 24th of October, his birthday, and the United Nations. UN's a little bit older than him. I mean, not the same birth year, but the same birth date. Yeah.
Yeah, I too would have smacked you in
Yeah,
the.
rightly so. I could see the pain she was in, far out, but still, I wanted to hang on. She did. Never been more grateful, actually.
Tim, it's just been really, really incredible having you with us today. And one of the reasons, I think, is because there is so much political obfuscation and distortion of the truth. And at university, we feel like we're often being gaslit and prevented from just telling the straight truth about things. And what we've heard from you today is just refreshingly frank and honest, including about the limitations of international law in this unbearably terrible situation we're in. And I know that we're very grateful for you allowing us to record this so that we can share it more broadly with all of the students who are so invested in what's currently happening. And I will just give the final word to the wonderful Iram, who hosted so beautifully today.
Thanks, Catherine. And I apologize to everyone's questions that we couldn't get through today, as we had massive amounts of feedback and questions. But Tim, I just want to say thank you. It's really refreshing to be able to speak to someone who's very frank, especially with the role you had. And I just want to thank everyone here. Thank you for your time. Thank you for listening and engaging and being part of this Palestinian project. And everyone's presence really speaks volumes about the importance of this movement. And I want to thank our incredible team. I want to thank all of our professors who always support the law students. It's such a meaningful impact. And I want to thank Catherine. You've given us the resources and the time for us to be able to grow and evolve this project. So I really do thank you. And I thank Sahar. She's been a massive influence in, this Palestine project. And I thank Rob. He has, inspired me, as he's my human rights professor, to really keep moving. So I just, thank you, everyone. I'll give it back to you, Catherine.
All right, nothing more from me other than Tim. Again, Western Sydney University's most heartfelt thanks go with you for today. It's been just wonderful.
Well, I really appreciate being able to join you, and I hope maybe in 2025 that I might be able to do it in person. Catherine, if there's an opportunity to do that, I'd love to come up and actually spend a little bit more time engaging one-on-one as well as collectively with the people who are interested. That'd be great.
We will definitely extend that.
Sorry to interrupt. I am heading back to The Hague one last time, even though I've formally finished in my role. I told the prosecutor I really want to come to be able to say goodbye to my colleagues and thank you for 14 and a half years of being in the role that I have. And that happens on, let's see, 9th of November, so it's a couple of weeks away from this weekend. And then, I'll be there for a couple of weeks, and I'm sure it'll be bittersweet, but I'll be glad to come back and say whatever I want to say. There's a lot to say.
Tim.
Yeah. Thanks very much for having me.
Thanks so much, Tim. Bye.
Okay. Bye-bye.
Thanks, everyone.
Bye.
Thanks, Irene.